Hi, this is Ted Gudorf from Gudorf Law Group. Today's topic is to discuss the difference between a will versus a trust. A lot of people have wills, and what they don't realize is that a will guarantees probate. A will is useless as a legal document until you die. It does nothing for you while you're living. And remember, it only transfers property that is in your name alone at the time you pass away. It does not have any control over jointly owned property or property that passes through beneficiary designation, whether that be your life insurance or your retirement account. Now, what is probate? Probate is a court proceeding where we publish a notice in the newspaper and we provide notice to all your creditors. Everything is public. Your will and an inventory of your entire estate is made public through the probate court process because they publish those documents online. Um, Typical probate in Montgomery County, Greene County, takes about 2 years. I've never seen a probate go longer than 10 years. Average cost lawyer fee can be pretty high. The cost is on typically a percentage basis, and it can be as much as 5% because it takes so long for it to get done. Now, how does that compare with a trust? Well, a trust is a legal entity apart from the person or persons who create it. It is designed to hold and control the distribution of property outside of the probate process. Now, a trust has three primary roles. One, a trust maker who creates and funds the trust. Two, the trustee who holds and administers the property in the trust. And three, the beneficiary who receives the benefit from the trust. Uh, as I mentioned, a trust is something that can be used to avoid probate. I like to refer to it as a bucket. So I create this bucket and I take what you own and put it in the bucket during your lifetime. So I'll put your checking and your savings and your CDs and your car in this bucket. And the law says that if you become incapacitated or die, it doesn't have to go through the probate process because you, in the trust document, you name somebody to be your successor trustee. And so you have an agreement with them to carry out your instructions outside of the purview of the probate court. So, how is a revocable trust different from a will? Well, a revocable trust, remember, is a private document. It does not become a part of the public record. Assets owned by the revocable trust pass free of all creditor claims. They pass free of living probate, death probate. Assets of the trust are distributed without any notice being given to any of your unsecured creditors. Therefore, trust administration is more efficient and cost substantially less. And frankly, I think challenges to trust are less likely to occur than they are with a will. So, will versus trust at our firm, we have a bias toward utilizing both revocable and irrevocable trust. Now, that doesn't mean you don't have a will, it's just that that will is a backup. Well, have a good day. I appreciate you tuning in and listening to this important message from Gudorf Law Group.